Hi, my name is Mark Silver. I'm back for another forensic program. I'm a forensic expert in New York City. I've been working at it for about 20 years now, done thousands and thousands of cases, and consulted on countless others. I've provided CLE programs for providers and others to tens of thousands of lawyers. And my specialty is specifically criminal immigration matters. And more generally, immigration, criminal, and civil litigation lawyers refer me cases. This first series of programs I'm doing have all been CLEs. I want to also provide them free for anybody that wants to see them through YouTube. I've been imploring AILA for many years to provide clinical forensic programs so that immigration defense lawyers will know how to evaluate cases, and they have not been interested in. However, local AILA chapters are very interested, and I've done many CLEs over the years for them, and it worked out great. I do them for free, and any CLE programs that AILA chapters are interested in, I'd be more than happy to undertake. Today's program is on immigration court expert testimony. And the subtitle is Psychosocial Evaluations as Evidence. Again, to my knowledge, this is a program that is not available anywhere else in the United States other than through my programs, and I hope it's helpful. A little bit about myself. I'm a forensic psychiatric social worker. I have a doctorate in psychology. I'm also a lawyer in New York. To the embarrassment of my mother, I never practiced law. And I also have a background in family systems therapy and political science. I have two books that I think might be helpful that I often talk about. One is this book, which is Psychosocial Evaluations and Consultation in Civil Litigation. The reason that I now really recommend this book for immigration and criminal lawyers also is because we have almost no opportunity in law school to understand how to evaluate a client's case. And I don't mean understand it legally, but understand the client, to elicit information, how to interact with the client, how to understand the client's concerns and needs, and quite frankly, how to avoid liability. And this book is very much focused on psychosocial evaluations, how clinicians undertake evaluations, some of the issues and challenges. And it's, I think, an incredibly useful skill. In fact, I spoke to several law schools many years ago about coming in to do seminars or having a full course for lawyers so that they will know how to talk with their clients and evaluate cases and so on. And it's had limited interest, even though I think it's absolutely crucial. Another book is Handbook of Mitigation in Criminal and Immigration Forensics. This is in the 7th edition. It's the 7th edition. It came out in 2021, just a few years ago. It really has a lot more than the other editions, but there is a specific chapter on every CLE, every education program I do for immigration defense lawyers in the United States, including for the topic that we're doing today. I promise these books are incredibly cheap compared to other AILA and criminal books used for practice by attorneys in the U.S., and I hope you find them helpful. Please do not hesitate to email me if you have any questions on these issues. In the large majority of my programs, I actually provide redacted samples of reports so that practicing immigration attorneys and criminal attorneys for those programs will have an understanding about how theory is integrated into practice. And I hope that's available for attorneys that are interested in actually practicing and understanding how these programs integrate theory with practice. Please email me and I'll send you a redacted, copy of a case for those CLEs that I've done. So I do all sorts of cases for immigration defense lawyers. There was a point that the large majority of them were removal deportation cases, which of course have the exceptional and extremely unusual hardship standard, which is very high. And that really needed particular explanation in court because it's such a high standard. Another kind of case that I would do is asylum, but specifically I would be referred 1 year bar issues. That is, the respondent would often miss the filing deadline by not months, but years and years, and there was a question, why in the world did this occur? And there was a great need to explain how the client's history of trauma and functioning and decision making and so on influenced the client in a holistic way, and certainly helps us to understand why the client did not have the wherewithal after arriving in the United States to petition for asylum within the 1 year. I've done a lot of spousal abuse cases. I've seen well over 1,000 cases, both for immigration lawyers and criminal defense lawyers, and that's another issue that can come up in immigration court. Criminal immigration, or sometimes called crimmigration, and my specialty there is mitigating fraud, misrepresentation, crimes, CIMTs, misdemeanors, just about any wrongdoing the client has committed. So not focusing only on the hardship to qualifying family members, but just as importantly, or more importantly for immigration court purposes, focusing on the mitigation itself, because that can sometimes be what makes or breaks a case. Another crucial area for immigration court is competency cases. I have a CLE, I have a program on YouTube for competency evaluations as well. They have nothing to do with competency cases that we remember from law school in the context of criminal law. Criminal law uses a completely different test, a completely different set of criteria for evaluating competency of clients to appear in court. The case there is, of course, matter of mem, and that's another essential reason to have an expert in immigration court. Clinical issues that are not obviously apparent or not documented really speak to the need to have a forensic evaluation. Some psych issues are well documented, but with the case with our clients in immigration defense work, it's quite unusual. Clients have suffered all sorts of trauma before coming to the United States due to poverty, the ubiquity of violent social and political unrest, drugs, alcohol, misogyny, all sorts of issues. And it's important that we are able to outline these issues, because these clients don't have sufficient documentation, and they need an expert to explicate what these issues are and then translate them in immigration court for the immigration judge and TA. The client cannot self-advocate. The client doesn't have the wherewithal, the vocabulary, the sense of trust, and their self-expression has to be reimagined through the clinical evaluation, eliciting information that can then be available to the expert, not just to, of course, write a report that is helpful as evidence, but to actually explain things within the report in immigration court. There are often a number of issues at play, and cumulatively understanding these issues for the client can be extremely helpful, especially if there's an overlap of hardship issues with criminal mitigation issues, as I've noted in other programs that I've put on YouTube. So these are some of the reasons to have the expert in court, and it needs to be considered in almost every single case. The first reason, obviously, that I'd go to court is that the lawyer makes the request. There's a lawyer I've been working with for many years, and he asks me to go to court in every single case. It's unusual. I've had a few lawyers that I've worked with in the past like this. But he says, look, this is a life-changing moment for my client, and he really cares about his clients. And he says, if you do nothing, it's still worth the investment. And I would say, well, why? And he says, well, look, you come to court early, You help the clients relax. You review the hardship issues with them. You review the hardship issues with me. Often, he says, because the case takes so long to get to immigration court, months or years, things have changed for the client, particularly for children. This is a huge area that I talk about in other programs. You have a client who has a child who is evaluated at age 6. 6 years later, the case is going to court. The child is now 12 years old. 6 years in the life of a child is a huge, huge developmental change. Many times the lawyer will say, look, it's like fire insurance. We're never going to have a fire. But the reality is that the well-being of the clients are at stake, and we just don't want to take a chance. Some lawyers say, look, the bar is very high. It's extreme and exceptional unusual hardship. And to have such a high bar, I think we need to use every available resource in order to prove that burden. Some lawyers ask me to go to court because they say, I want to get it on record. I don't want your report just to be accepted. You wrote a long report. There's a lot of words. It's a lot to take in. Everybody's very, very overwhelmed in immigration court, and the lawyer will say, look, I want you to be able to summarize or, sort of pick the best parts or those areas that, the judge or the TA may not focus on at all for one reason or another, or those areas that you think are particularly important clinically that the judge or TA may not think are particularly important. Many times the lawyer will say, look, the parents or the kids over several years have seen a psychotherapist, which is good, except the lawyer will tell me the psychotherapist does not want to go to court, does not want to testify. They're afraid of liability. Perhaps the therapist has never testified, and the lawyer is worried that the TA is going to grill them on cross-examination. Another major reason that lawyers ask me to go to court is that mental health issues can be very subtle. They can be atypical. They can be not very well recognized by the client himself or herself because mental health issues were not particularly well recognized in their culture or in their country of origin. So these are reasons to have an expert go to court. I've also had cases where the lawyer said, look, if you go to court and you're not permitted to testify, you're physically there, you can testify and talk about all sorts of issues related to the report you've written, and you're not permitted to testify, the lawyer says, well, that could be an appeal issue. So there are many reasons that the lawyer asks me to go to court. The other next major reason I go to court is that the client asks me to go to court and not the lawyer. Some clients have difficulty expressing themselves. They may be uneducated. They may be inarticulate. English may not be their best language. They may be quite fearful of authority. They may do very well in your office, the client. The client may do very well in my office explaining their situation. That doesn't mean the client is going to do very well in immigration court. And the client may say, I want you there. We'll go over the case in the morning. I'll feel better knowing that you'll have the opportunity to testify, or that you can help review the case with me, and so on. Some clients also feel that it's really the end of the road for them. As immigration defense lawyers, you're aware that some of these cases go on for years and years and years. And the client feels, I've invested this much in terms of my energy, time, and quite frankly, money as well. I'd rather spend a few more dollars, have you come to court, even if you do nothing, just so we know that we did everything possible in order to present the case in a professional way. Another main reason I go to court, and it's quite unusual, is that the judge or the government makes the request. As I said, this is quite unusual, but sometimes they do have questions directly from the report or other issues, and it can happen. It's not necessarily a bad thing, and my general rule of thumb, I think, is that the more explanation and information provided, the more that gets on the record and the more substantive the facts as understood by the adjudicator or the immigration judge. It's also the case, I think, and I see this in RFEs, which is a different kettle of fish, but there's a parallel, where I think sometimes the judge, or maybe even the TA, they're persuaded by the hardship evidence, they're persuaded by the criminal mitigation evidence, and this is another program I have, but they need something to hang their hat on. They need to just get over the fence, and sometimes hearing from the expert can be sufficient, allowing them to make that decision and grant the case in favor of your client, the respondent. The next thing I'd say is that immigration defense work in court is litigation. Litigation is litigation is litigation. You know, that's what we learned in law school. There should be no surprises. There should be no surprise questions. And, you know, getting a good report from an expert and then not having the expert there and having questions about the report that the lawyer can't answer, that the client becomes confused about, is really detrimental to the case. There's also a huge advantage, and I've spoken about this before, about having the expert there just to conference the case before court begins, even if it's only for 30 or 60 minutes. You know, sometimes it's months or years before the case is adjudicated in immigration court. It's an opportunity to converse with clients for a wide issue of concerns that can be very important. I'll give you a really interesting example. I had a case, this is years and years ago, probably 15 years ago. It's a very nice family from India, and there was a familial history of respiratory distress due to asthma. And when I saw the client in court, the respondent, he was there with his kids. I said, "How are you doing?" And we talked a little bit, and he was quite down, and he revealed that his mom had passed away in India. And I gave my condolences, although I was a little surprised because I knew she wasn't that old. And he said, no, she died not from asthma, she died from a power outage. I didn't quite understand what he was saying. But what he was trying to convey is that his children did well in the United States because they inhaled their medication through a nebulizer in their room. And his mother had the same machine in India for her asthma. But there are frequent power outages where his family lived in India in this rural agrarian community. And it happened enough that the machines weren't working because the electricity wasn't off, and therefore she couldn't get her medication. She suffered acute respiratory distress and passed away. You know, so going to court that morning with the client, he told me this personal story that was really very, not only touching and sad and amazing, but it reflected something very fundamental about medical hardship issues, about country condition hardship issues, and so on. Another example is that mental health is like medical problems in that they're not consistent. You have periods where you do better or you do worse. You have acute problems, chronic issues. You have emergency problems where you need to go to the hospital and so on. And a client, you know, may come to immigration court and they're doing really quite well. They're functioning well. They're going to work every day. They're interacting with friends and family, engaged in hobbies and activities and so on. And the judge will see the client and they'll think, this person's doing pretty well. But just underneath the surface, you realize there's someone who's very fragile and vulnerable, and it doesn't really necessarily show because the person is perhaps compliant with their psychiatric medication or they're doing well or whatever. And the person doesn't express themselves in a way that reflects their mental health history, and it could have really a benefit to the proceedings if the expert is there. When I testify, one of the things I find is that I'm able to direct my testimony to one person. There's no stenographer, there's no jury, of course. It's just a few people in the room, and having the opportunity to speak one-on-one with somebody is really invaluable. It allows for a kind of intimacy and congenial atmosphere that you just wouldn't otherwise get. It may also allow the forensic expert to make a point that may not otherwise be available. I had a case many years ago. This was a client with schizophrenia. It was actually an asylum case, and because of his mental health issues, he was involved in stealing from stores. And I didn't sort of think about this in the report, but one of the things that the immigration judge asked me, because he was so upset about the client stealing, even with his asylum case, he said, "Oh, won't this happen in the future?" And I said, I didn't think about it, but I said to the judge, "This person is very ill. It's quite possible that there'll be periods when he will return to erratic behaviors and unstable moods because of his mental health problems, and may even steal again. And it's precisely for that reason that he needs to stay in the United States, because he's not going to get proper psychiatric care in Syria. He's going to degenerate and decompensate, and he has to stay in the United States for human rights reasons to have these psychiatric supports here." Another reason to be in court is that, for me at least, I get to know the frame of mind and the presentation of the immigration judge. Doing this on the phone is very difficult. I once had a case, this was many, many years ago, where the clients didn't want to pay me to go to court, and the immigration lawyer thought it wasn't really necessary. And I didn't know what was going on in court because I wasn't there, and the immigration judge called and asked some questions, and it didn't go very well. And afterward, the immigration defense lawyer said, "Well, couldn't you get a sense of what's going on?" And I said, "No, I wasn't there. You were there, the clients were there, the judge was there, the TA was there, but you didn't want me to be there." No, it was very difficult for me to get a sense of kind of which way the judge was leaning and what kind of questions were more or less important to her. I didn't know. So the advantages of being in court are huge. There's also the uncertainty factor. Courtroom proceedings are inherently unpredictable. The predilections of the IJ and a host of other factors create an environment that does not provide much room for certainty of outcome. The immediate availability of the expert in the courtroom can provide the lawyer with an added element of reassurance, particularly if there is serious mental health issues and family issues involved, which may require clarification, whether this is immediately before the hearing, during the hearing, or during recess. I had one case, this was about 6 or 7 years ago, certainly before the pandemic, and the respondent really did not do a good job testifying, even though he had very direct questions from the attorney. The attorney prepared the respondent very well, and he just didn't do a good job. And then I testified, and I really helped clarify some very basic concerns that the TA and the judge had. And the immigration attorney was very nice and was very thankful, and the respondent didn't want to pay me after immigration court, and the lawyer said, "You just messed up for the last hour or hour and a half in testifying, and this person came in and was able to clarify. If he wasn't here, the judge would have been left, and the TA would have been left with a very, very different impression of the case before deciding it." So, sometimes the respondent, who in the office may be quite prepared to testify in a way that's very helpful for himself or herself, in reality it doesn't turn out that way, and having the expert there for clarification can be very helpful. Phone testimony is a problem. There can be annoying interferences. There's call waiting, beeps, poor reception, static. There's shuffling of paper. It's disorienting if you're not there. I know because of the pandemic, many are done through Zoom calls now or the comparable technology. When you're in the courtroom, there's a sense of what's going on. There's a sense of mood. There's a sense of urgency. There's also a sense of, priority. Judges are very busy, and you can get a sense of how quickly the judge wishes to move along. I mean, I've seen cases where I've been in court, in earlier years where the judge really seems like, well, there's just a lot of time to work with. And quite the opposite. I've seen some cases where the judge is clearly wishing to move along very, very quickly so that they can get through by 12 noon, for example, because their docket in the afternoon is even more full. Distractions can be very serious. Body language is extremely helpful, not only for me as I use body language to express myself, but to find out the body language of the TA or judge. And I can get a sense when I say something when I'm testifying as to whether the judge or TA took it in, whether they believed it. It's not always possible. There's some judges or TAs that are very, very difficult to read, but there have been times I've sort of repeated myself or said the same thing in a different way, trying to emphasize an issue, primarily because I wanted to make sure that it is properly understood, because the judge may be skeptical or the TA may be uncertain of one matter or another. One of the things that can't be done easily by telephonic is body language of security. In other words, a sense of stability, security, that the client has a sense of safety, well-being. That kind of tone, that kind of body language is very difficult to do. And it's both subtle, but it can be overt as well. I'm very much aware that one of the bottom lines of all this is that it can be expensive to have the expert go to court, even if it's only for a few hours in the city, whatever city you're in. But, you know, I see clients all over the United States, and I may have to fly somewhere. If the case is at 9 a.m. in the morning, obviously I have to fly the day before, so it's 2 days. And it's an expense, it's a reality. But, you know, the difference between live and telephonic testimony for an overall cost of what the client's paying for his immigration case over many years may not be that great, and yet considering the impact of live testimony and the gravity of the issues at hand, it may be something to consider. One of the crucial concerns is stipulations. We learn in law school that stipulation is an agreement between opposing counsel to submit documentary evidence without the need to examine the probative value, bias, or relevance of the evidence either in pretrial motions or during formal litigation. And in immigration courts, everybody's happy because it's busy, and you know, the immigration defense lawyer is happy when my report gets stipulated to and is recognized as part of the formal record. The problem is, I then question how well it was really absorbed. Was it read twice? Was it read carefully? And if not, you know, there may be a real need to review particular areas of the report so that even if it's stipulated that it's in the record as a whole, which is theoretically great, practically speaking, the judge or TA, you know, may not have absorbed it. And I have been in court countless times where the TA has clearly not looked at the report until 5 minutes before the proceedings begin. And what I usually see is that the TA focuses on a few paragraphs in the beginning, reads the conclusion, because the conclusion I usually put in bold and I have a long conclusion, and then goes back and looks at certain areas. The TA is very busy as well, I understand that, but you know, it's a pitfall of stipulation, a pitfall of stipulations in that on the one hand, everybody's happy that they're integrated into the record because it's a stipulation, but the reality is it's not quite clear to what extent it's really, the report is really carefully read and considered. And for that reason, stipulations have to be really, really thought about once and twice and 3 times. It's important that if there are biases and prejudices on the part of the TA or lawyer in immigration court that need to be tackled, that it can be very helpful to have the expert there to clarify certain issues. This is particularly the case, and I have other programs on this, where there are criminal mitigation issues where the respondent has committed one or more crimes or even CIMTs, so that the way the judge perceives the client based on their history of behavior or illegal conduct or wrongdoing can be better explained in the context of their overall functioning psychosocial history, traumas, challenges, and so on, so that their unfortunate judgment or the ways in which they've undermined themselves or jeopardized themselves and gotten themselves into trouble can be really much better understood. These are very high standards in immigration court, of course, the exceptional, extremely unusual hardship standard. And I really presented this program to reiterate something that immigration lawyers ask me about a lot, and that is the value of having the expert there, not just preparing a report that is used as a basis for the case, and the report can be stipulated to, so it's entered into as a complete document into the record, but to have the expert there in immigration court to review the case again in the morning, to help calm the client, to see if there's any updates, to be able to confer with the lawyer and the client about strategy, about how the case needs to be presented, pitfalls, challenges, issues that the TA or judge may have with regard to biases or prejudices, and how they can really be tackled through proper presentation by the expert in court, through language, through body language, and so on. And hopefully this program will give the immigration lawyer listening to this a better sense of why it's so important not only to get a forensic expert evaluation done, but in all possible cases to have the expert available in immigration court to present and testify, and even if they don't present and testify that day, to help in other ways in the immigration proceedings. Thank you very much. Again, really trying to get AILA to include clinical forensic programs because it's so important. If you have any questions, please do not hesitate to email me. Just put something in the subject line so I know it's not spam, and I'll be more than happy to respond. Thank you for listening today, and click the like button, and hopefully I will present the rest of the programs and CLEs for free on YouTube for all lawyers to share and listen to. Thank you.